Court does call the case of the people versus Cecil Bates.
Well, he was on behalf of the people.
Public defender on behalf of Mr. Bates, who is not going to be present, Your Honor.
Pardon?
He's not going to be present, Your Honor. My understanding is that Mr. Bates is deceased, and that my office has tried to get sent a medical report from Kalamazoo to Ms. Hughes. We're trying to get an obituary to Ms. Hughes. We can get this matter closed out.
So you're trying to verify that? Okay. So what I will do is I'll adjourn these matters out 2 weeks. I'll adjourn it out to the second.
Thank you, Judge.
You guys time to get that done. No, lady, you're getting back up there. Court does call the case, people versus Benjamin McFadden.
Assistant Prosecuting Attorney Morgan Burroughs on behalf of people. Public defender here on behalf of Mr. McFadden. Your Honor, can I have 1 moment briefly?
Do I have a choice?
Adjourn this together. The same person.
Yeah.
What was that? I mean, please.
Just
Cause of delay. Thank you, Your Honor.
Oh, okay.
Your Honor, we are asking for an adjournment of the probable cause conference.
Probable cause conference will May 2nd work for
Yes, please, Your Honor.
May 2nd, 2024, 9 a.m. bond continue.
Your Honor, I do hope to address that.
Oh, I'm shocked. Go ahead.
In this case, we requested $250,000 cash secured, $5,000 bond, as well as, I believe, no GPS tether. In this case, he is currently on probation for assault, which he was convicted for in August 28th, 2023. That was reduced from an ag assault. That he was on probation for that when this offense occurred. Since this offense has occurred and he was out on bond, he has since been charged with witness intimidation and aggravated stalking for continuing to contact the victim in this case.
I'm just trying to make sure. So he posted on this.
Correct.
He's out.
Correct.
And now there are new charges.
For witness intimidation and aggravated stalking. He has not been arraigned on that. The expectation is that he will be arraigned on that later today. Additionally, we charged him in late March for larceny in a building. It is important to note that that offense date is from July of last year, but he does have 2 new felonies coming. He has not been arraigned on that either, but.
Well, hold on. When you say he has 2 new felonies coming, those are the new ones. Okay, gotcha.
So with all of that in mind, I do think that the $5,000 that he was given in this case is not appropriate. We would have asked to address bond today, given the fact that we initially requested $250,000 had the witness intimidation and aggravated stalking not been added on or had not been a new case. But given the continued threat to the victim and the greater community in this case, we would be asking for an increase in bond.
Any response? I guess.
Your Honor, no response at this time.
All right. I will increase the defendant's bond. I certainly will take a look at it, but one thing is that if this allegedly occurred while he was on probation for another offense, especially if.
Your Honor, I do think it's important to note that this incident the actual assault, DVH, strangulation, and FA that we're here on today was a report from the hospital because the victim had such severe injuries that she was admitted to Trinity Health ER. The defendant picked up the victim, shook her, slammed her onto a glass coffee table, breaking the coffee table, grabbed her by the throat, putting pressure on her chest. He gripped her by the throat, placed his forearm on her throat, and she was only able to get him off by taking him off of her, but he came back at her with a drill fork, held it to her neck, and said that he would kill her and then kill himself. She was so scared that she didn't initially make a report to law enforcement. It was only after she started, it was only after law enforcement, or she told law enforcement that the defendant was stalking her and continued to call her that she decided to actually tell law enforcement his name. So we have the compounding concern of the threats, the injuries, and the continued pattern of behavior in this case.
And the allegations of witness intimidation when this individual got out, those are,
From April 5th to April 12th.
but those go directly to the alleged victim in this case?
Correct.
Anything, Ms. Apple, or no?
No, Your Honor.
Defendant's bond in this case will be set in the amount of $200,000 cash surety. Thank you. Well, and if the defendant does find a way to post, there will be a home confinement GPS tether. And I'm signing that order. So if he does post, he's on a home confinement GPS.
Understood.
Thank you.
Please on record David Burgess on behalf of Michael Vigor, standing at right.
Sir, your name?
Michael Vijay.
My bad. I was being phonetic. Your Honor, today's date time set for probable cause in this matter. I've spoken to the prosecutor. We are going to attempt to resolve this. We are asking for an adjournment of the probable cause conference to May the 2nd. That's okay with the court.
Couple weeks out.
Yes.
Any objection from the people? Probable cause conference, May 2nd, 2024, 9 a.m. Bond continued.
One issue as to bond, Your Honor, discuss this with the prosecutor. My client's mother, who's not she's a potential witness in the case, but not a complainant at all. There was a no contact issued at the arraignment in this case, based on she did have the minor. There's a minor child that she did have custody of. She no longer does. Your Honor, the biological mother now has custody of the minor child. I did receive a letter, if the court wants to see it, from my client's mother, indicating that she's not a complainant in the case. She does not have personal contact with Carter, the complainant in this case, Judge, and he does not reside at either of her residences. If the court wanted to see the letter, I'm not sure. I just was going to ask that no contact be lifted. So
With Heather?
Not Heather. Heather's the biological mother, Your Honor. Lisa Gotti, Gotte, for the record, Your Honor.
I don't, that's the one you want lifted.
Correct, Judge.
And I don't have that as a no contact.
Okay. Well, initially there was some concern. There was that she was listed as no contact. If she's not, Your Honor, then it's not.
The only no contact I have is 11-year-old child and Heather Lindermuth.
Okay.
That's all I have.
I just
Exactly as it should be.
okay. Yeah, that's fine. If that's all the order indicates, Your Honor, that's fine with.
All right, and we'll continue. Okay, thank you.
I did just want to,
Oh,
I know that that has been ordered, so I don't know. if you-
what had been ordered?
That no contact with the grant. That's not on your report.
That is not on the form that I have.
Yeah, Your Honor, I was going to leave it in the court's discretion if that had been in order. I will say that it had been requested because the grandmother showed up on the scene and tried to remove the child.
Got it.
So the child could speak to. police or.
Okay. Yeah, it's not on here.
Your Honor, may I just request that if
Really?
not a no contact, but that he be ordered not to discuss the case with that individual, given that she may be a witness.
I will advise my client not to commit the separate crime of obstruction of justice, Your Honor. That's not a problem.
Okay, very good. I'll leave it there. I trust Mr. Burgess will do that.
Thank you very much.
Decide not. All right. Thank you. Brighton. Is it Brighton Warren?
Morning, Your Honor. For the record, my name is Jeffrey Bennett. I'm appearing with and on behalf of Mr. Warren today. Mr. Warren, can you state your name for the court, please?
Brent Warren. All right, what are we doing?
Your Honor, at this time, I do have all the discovery. I am requesting a preliminary examination, and at the appropriate time, I'd like to address.
People would have their witnesses available the 30th. Preliminary examination will be set April 30th, 2024, 9 a.m. in person before Judge Barr. As to bond.
Your Honor, the bond is currently set at $250,000 cash or surety. The most significant charge is assault with intent to commit great bodily harm, murder. The allegations in that are that the alleged victim threw a bottle at Mr. Warren. He grabbed her hair and she put her to the ground, and as she did, she hurt her wrist. He does have a criminal history, but he is a lifelong resident of Ypsilanti. Resides now with his mother since him and the alleged victim have split up. He's employed, does DoorDash and Uber. He does also have a child, which is the alleged victim in this case in the area who he's been seeing and trying to support. And he also has a support of I believe that $250,000 is an excessive amount of bond. I would actually request the court to lower the bond at a condition of a GPS tether, and we could certainly geofence him away from this alleged victim's residence and work.
Response.
Judge, the defendant was recently released from parole, serving a sentence for manslaughter. He was on camera in this offense, damaging the security system. He actually broke it. He tried to remove her door camera from her house. He punched it several times, removed it. He broke the victim's wrist in the incident that defense counsel is talking about, where he pulled her to the ground by her hair. Her wrist was broken. She finally made a police report to the police when he damaged her tires and slashed her tires, and that's when police were involved. I have serious concerns from victim safety. The police officers had serious concerns. They actually called me on the weekend on this case, extremely concerned about the victim and the stalking behavior of the defendant, that he just wouldn't leave her alone. I believe bond is reasonably set. We actually asked for a $500,000 bond at the time of arraignment. So I'd ask you not to change the bond. Thank you.
Anything else?
Your Honor, the allegations that rise to the stalking are alleged to have occurred over a long period of time. These charges miraculously appeared after Mr. Warren addressed the fact that the complainant had taken his tax refund check. The day after that happened, we get a slashed tires and a call to the police. So I know that Mr. Warren has no interest in being around her. He certainly denies all the charges, by the way, including the assault. But I'm just going based on what her allegations. This is something that the most serious allegation is the GBH, and that incident, which I don't even know when it happened. It's not in the report, was triggered by the alleged complainant. I believe that a lower bond with a GPS tether is adequate to protect.
Did he just get off of federal parole?
No, state parole, Your Honor.
State parole?
Yes,
So he was just released from parole. What time, when was he released from parole?
July of 2023, I believe, right?
July, I was
Any
Released.
parole violations.
no parole violations.
He served 7 years
There
and 2
haven't
months
been
on a
any
manslaughter and had no parole violations while released on parole.
Right, I understand that, but then within this behavior, at least according to the allegations, begins within 4 months of the time that he's released from parole.
That's when the allegations arose.
Right.
I certainly have a different view of what these allegations are.
All right. Well, everybody can sort that out then maybe on the 30th, but motion for bond reduction is denied. Bond. Thank you.
Thank you, Your Honor.
Case People versus Alyssa Cox.
Prosecuting attorney.
Assistant Public Defender, Nina Applewood, on behalf of this call.
Okay, what are we doing?
Your Honor, the court should be considering the plea.
Does have a plea form. The plea form indicates she's going to plead guilty to the charge of use of heroin, the 1-year offense upon her successful plea to that charge. Well, I got my numbers here. Is that a count 3?
Count two.
Should be a count 2, Your Honor.
Right. I have 1, but then it says count. I got it. So where it says count 3 under the, got it. Okay. Well, so 2 corrections on the form then. Under offense, where it says it should be count 2 use of heroin, the 1 year. And then what would be dismissed would be just count 1.
Correct.
Correct.
Got it. So that she's going to plead guilty to an added count 2 of use of heroin, the 1-year offense. Upon her successful plea, count 1 would be dismissed. And there is no objection to 7411 on count 2 if otherwise eligible. That is court's full understanding of the agreement.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony about to give the truth, the whole truth, and nothing but the truth to help you God.
I do.
State your name.
Alyssa Cole.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of heroin. Is that correct? That is a misdemeanor that is punishable by up to 1 year incarceration and a $2,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
Understanding that, you still wish to plead guilty?
Yes, Your Honor.
I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, I understand.
All right. Still wish to plead guilty?
Yes.
All right. To that charge, how do you plead?
Guilty, sir.
On the date of September 27th, 2022, 317 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan. Well, it's interesting. Okay, that's quite right. Did you have fentanyl in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
Did you know what you were using was fentanyl?
Not really. Yes, I did. You never know with that stuff, I guess. I did not know it was fentanyl, but I thought it was heroin.
I thought it was heroin.
Yes, sir.
All right. And the only reason I'm asking counsel is because the complaint was it looks like amended to fentanyl and heroin was struck.
I did not have, I apologize, I must have missed that. I didn't have that as the
Okay.
complaint, but I had heroin listed.
But you knew that it was one of those 2.
Yes.
Because you don't know, right? And you used it.
Yes, sir.
All right, counsel.
That's fine.
That's fine.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14 to probation. Sentencing in this matter will be,
12 to 10 a.m. before Judge
what'd you
Ross.
say?
June 12th at 10 a.m. before Judge Ross.
June 12th, 2024. What time?
10 a.m.
10 a.m. before Judge Barr. Bond will continue. Versus does your Exton.
And Matthew Mansour, Assistant Public Defender, with and on behalf of Exton. Here's my right. Exton, can you state your name for the record, please?
Deja Exton.
I have before me a plea form that indicates that the defendant would be pleading guilty to added counts 3 and 4. 3 being attempted possession of a loaded firearm in a motor vehicle, the 1-year offense. And count 4 being use of a controlled substance, also the 1-year offense, also a 1-year offense. On her successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's entire understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give the truth, nothing but the truth, so help you God.
Yes.
State your name.
Deja Exton.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that correct? First is the charge and added count 3 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon. You understand that?
Yes.
Count 4 is use of a controlled substance. That is also a misdemeanor punishable by up to 1 year incarceration and or $2,000 fine plus court costs. Do you understand that?
Yes.
You also understand, ma'am, while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Freshour in the 14A4 District Court.
Yes.
Still wish to plead guilty
Yes.
to the charge of attempted possession of a loaded firearm in a motor vehicle? How do you plead?
Guilty.
To the charge of use of a controlled substance? How do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today. Is that correct?
Yes.
Any questions regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of a trial. By pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yeah.
Of your own free will?
Yeah.
Because you believe that you are indeed guilty of these offenses?
Yes.
On May 22nd, 2023, at the location of Tower near Ann Arbor. Yes, okay. In the city of Saline, Washington County, state of Michigan. Were you in a motor vehicle?
Yes.
Did you have a weapon in that vehicle?
Yes.
What was it? Was it a pistol?
Yes.
Where was it located?
Under the seat. In the Kia Soto.
I'm sorry?
In the car, in the Kia Soto.
Got it. You don't have authority to carry a weapon in that fashion. It was in the passenger compartment, correct?
Yes.
You don't have permission to carry it in that fashion that you were carrying it, do you?
No.
All right. Did you also have in your possession heroin and or fentanyl?
Yes.
Had you used it?
Have I used it? Yes.
Had you used it? Okay, and you knew what you were using was heroin and or fentanyl?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
That's satisfied, Your Honor.
Court will accept the defendant's plea of guilty. 2 counts 3 and 4 counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
April 23rd at 9 a.m. before Judge Freshour.
April 23rd, 2024, 9 a.m. before Judge Freshour.
Your Honor, my client would like me to address bond.
Go ahead, briefly.
Thank you, Your Honor. Ms. Exton is Michigan born and raised. She's a Detroit resident. She's a full-time mother with full-time custody of a 3-year-old daughter. She works full-time at Amazon at the Brownstown location. She's not sure if she still has that job, but she's been employed there ever since November. To my knowledge, she has no open criminal cases. She's not on probation. She's not on parole. Her iChat is clean. Her record of appearances in this court, she's never missed a date. She does not own or possess any firearms. She has no plans to leave the state of Michigan anytime soon. We know she has not been perfect while testing on bond. She has spent the entire week in jail. She had a lot of time to think and reflect on her mistakes. All this time away from her child. Her 80-year-old grandmother is struggling right now, trying to help take care of that child. Your Honor, I'm asking for a PR bond on her behalf, allowing her one final chance to show you that she has learned from her mistakes, and she personally would like to apologize to you herself.
I can speak. Oh,
If you'd
yeah.
like.
I apologize for the way my attitude been perceived in this court.
Perceived?
I mean, I apologize. That's not who I am. I had a lot of time to reflect on my actions and I learned my lesson. I don't want to be that person.
Your Honor, can I speak?
I don't know who you are.
Oh my God.
Yelling from the, who is that? Who are you?
My mother.
Go ahead, ma'am. I need your name.
My name is Heather Gregory, and you're right next to mother. I'm here because she do have a 3-year-old child that's a special needs child. I work all the time, over 60 hours. I just came back from out of town, and my mother is struggling to take care of her daughter, by herself because we just lost my father. If we gotta have on a tether or whatever, Your Honor, we definitely need her home. Because my mother cannot take care of the child and I work too much.
She explained to you what she did?
She did.
She did not?
She did not. She did not tell
Okay, let me just put it to you this way, Mom. She's in custody because she worked her way there. I mean, it wasn't just where I just threw her in. She was coming, she had issues over with an attitude problem over at community corrections and doing stuff there. I gave her a warning. Didn't lock her up. She was supposed to be testing. She was supposed to be doing everything. Next thing I know, she shows back up here and she not only has abnormal creatinine levels, which would be positives at any event. I was still giving her the benefit of the doubt, but then shows up with cocaine in her system. That's how she ended up locked up. So the difficulties are not because of anything the court's doing, it's because of what she's not doing and then not telling me the truth.
I mean, like I said, I didn't know the full extent. I've been out of town, I work out of town, in and out. So I didn't know what happened, but she was court, I know you had locked her up. And like I said, she got a special needs kid, a daughter that has cerebral palsy, my mother is trying to take care of. And if I know she's not perfect, and I know she has an attitude
Oh, yeah, she does.
problem, which I mean, she might have got it from me, but I definitely need her home because I got this grandchild that needs her. So over all that, Your Honor, I'm just asking, can you please give her another chance? If I gotta watch her, I will, but I definitely need her home for my granddaughter's sake.
Any response from the people?
No.
Thank you. Thank you, Mr. Gunnar. Outside of that, Mr. Why should I even bother letting you out? Because I just have a feeling what's going to end up happening is Judge Freshour is going to have to lock you right back up.
I'm not gonna be the person that I was. I had time to think in jail, trust me. I don't want to be there.
Their previous month. Of course, messed everything up. Mhm. $5,000 personal recognizance bond. I'll reinstate previous conditions.
You need to thank him.
Thank you, Joe Simpson.
Thank you,
You
Ron.
what?
She would get a different date.
Yeah. Difference. But hold on. Reinstate the previous conditions. Also indicate that there's to be no further tests. I will also order a GPS tether. Home confinement, except work.
Your Honor, could I get that date one more time if it changed? For
She
sentencing?
can give it to you yet.
I'm sorry.
Sentencing date now will be one. May 14th, 2024, 9 a.m. before Judge Freshour. Be sending a note to Judge Freshour. So, young lady, if you mess up one bit, trust me, you'll be right back. Understood?
Yeah.
Thank you.
Thank you, Your Honor.